As part of a divorce, the court will determine child custody, which is now called time sharing through a parenting plan. The parenting plan establishes who gets the children and when. It also affects decision making, where the children go to school, and who ultimately, if anyone, has a say if you guys can't reach a decision together. A lot of people ask about what the difference is between legal custody and physical custody. In Florida, we don't have those at all. We call it parental responsibility, which is the decision making, and the parenting plan, which is the actual time sharing schedule. What you may think of as custody, the court calls time sharing. Time with your children is determined in Florida on a parenting plan. The presumption, meaning the starting place, if neither side presents evidence, is equal 50-50 time sharing. It is not guaranteed to happen. In fact, this past Monday in trial, I defeated that presumption and got my client majority time, and the other side only gets every other weekend, Friday to Sunday. That's it. 50-50 can be overcome, but that is the starting point for all custody cases in Florida. Child support is calculated based on three things: parties' incomes, time with the kids, and expenses for the kids. Now, when I say expenses for the kids, I'm referring only to insurance for the children, daycare expenses, which is required because of employment, or if agreed upon, private school expenses. The best interest of the child is controlled by Florida Statute 61.13 3A through T. That lists 20 factors where the court must make specific findings of facts. What do I mean by that? I mean the judge literally has to say factor A in favor of mom, factor B in favor of dad, factor C neutral, all the way A through T. This is a requirement in all divorce cases. In other words, the court will look at the behavior of the parents, the involvement of the parents, whether the parent encourages a positive relationship with the other parent, whether the parent is actually interested in their child at all. All these will be considered when determining what is in the best interest of your child or children. Modifying a custody or time-sharing agreement can be modified, but it requires a substantial material change in circumstances. During the original case, the court is only looking at what is in the best interest of your child. To modify that, before the court can even look at that, we must allege and prove a substantial material change in circumstances since the entry of that original parenting plan. There's two different questions about what if time sharing isn't happening according to the schedule. If you are trying to see your child according to the schedule and the other parent is not letting you see them, we can file for contempt. Contempt includes penalties, including fines, sanctions, and even incarceration. Yes, your spouse could go to jail for keeping your kid from you. They could also be liable for all of your attorney's fees incurred in enforcing that time. On the other side, what if your spouse isn't even bothering to see the kids? They agreed to 50-50. They're paying child support based on 50-50, but they don't even show up for 50-50, or maybe not at all. You can pursue additional child support based on the time that the other side is actually seeing the kids. If you have your kids more, you deserve to have help with the financial responsibility of having your kids more.